included 2 counts. Count 1 was the offense of aggravated vehicular homicide in violation of Revised Code Section 2903.06, a felony of the 2nd degree. Moreover, you were indicted on count 2, Mr. Cordle, operating a vehicle while under the influence of alcohol, a per se violation, in violation of Section 451119. Now, you appeared before the court on September the 11th at an arraignment before another judge of this court. At that time, you entered a plea of not guilty. In other words, denying the truth of the allegations set forth in the indictment. Now, subsequent to that plea of not guilty, I have consulted with the prosecutor's office and your counsel, and it's now my understanding that you wish to withdraw that previous plea of not guilty after consulting with both your counsel and proceed today with a plea of guilty to the counts I just identified. Is that correct?
Yes, Your Honor.
I want to make sure this is your signature. I'm holding an entry which has been presented to me, and that appears to be your signature on that entry. Is that, in fact, your signature on that plea entry form?
Yes, Your Honor.
All right. Is there anything that I reviewed with you thus far that you do not understand?
No, Your Honor.
All right. Just as I reviewed with you just a few minutes ago, the possible penalties that may be imposed.
Yes, Your Honor.
Are you entering the plea of guilty to these 2 counts, counts 1 and 2, knowingly, intelligently, and voluntarily, without any threat or promise? In other words, you're doing this on your own free will.
Yes, Your Honor.
I want you to understand that a plea of guilty to these 2 counts, counts 1 and count 2, are admissions of your guilt, and the court could proceed with sentencing. Moreover, the court costs may be imposed at the time of sentencing. Do you understand that matter as well?
Yes, Your Honor.
Now, on this important...
Yes, Your Honor, I do, and I would parenthetically note for the record that because this case is in the early stages of proceedings, there was no discovery request, but that we in the last week provided a full copy of our file to defense counsel so that they could be fully advised of what the state's evidence and investigation showed. So they had the benefit of our entire investigation while they were consulting with the defendant about the entry of the guilty plea.
Correct. Thank you.
And those facts, Your Honor, would indicate that back on June 22nd, in the early morning hours, that police were called.
What do you say the early morning hours? We're talking
2:40 a.m. 2:40 a.m. Your Honor. Police officers were called because of a 911 call that had been made on a wrong way driver on the downtown Interstate 670. The call indicated there was a white pickup truck heading eastbound in the westbound lanes of I-670 at Neal Avenue. Approximately within minutes, there was a supplemental call that the wrong way driver had hit another vehicle head on in the area of 4th Street. Columbus Fire Heavy Rescue responded to the scene. They found a tan Jeep in which the victim, Vincent Canzani, was located. He was 61 years old. He was pronounced dead at the scene by the heavy rescue squad. There was the at-fault vehicle was a white Toyota Tundra pickup truck. The driver the wrong way vehicle was identified as the defendant. There was no other person in or around the area.
No passenger in the vehicle.
There was no passenger in the vehicle and no indication any other person had been in the vehicle other than the defendant. He was identified because he was injured and transported to a local medical facility. He was identified through his driver's license on his person as the defendant, Matthew R. Cordle. The vehicle actually had rolled over and was sitting on its roof when the police arrived at the scene. The vehicle was leaking gasoline, and the officers initially were not able to get close enough because of that to take steps to extricate him from the vehicle. He was fading in and out of consciousness. Upon their original arrival. He was eventually extracted from the vehicle, transported to Grant ER. They followed the squad, the police followed the squad to the hospital, both in connection with the defendant. He was treated in a trauma room at Grant. They were advised he had possible skull fractures and a possible cracked vertebrae. Several members of the hospital staff and the ER advised the police that the defendant was very, very drunk. Advised security staff that he had 6 beers. The officer spoke with the defendant in the trauma room.
6 beers in what period of time?
He didn't state what time period, Your Honor, nor was that amount verified through any independent source. But he did get interviewed by an officer in the trauma room once he was stabilized. He did say he had a few drinks. He stated to the officers he was heading home. The officers asked him if he knew what had happened or where he was, and he had been involved in an accident. He didn't seem to know that he had been involved in an accident at that point. While they were talking to him, the officers detected a strong odor of an alcohol beverage about his person. They did at that point and advised him that he was involved in a fatal accident. He was responsible for the death of another person. They advised him he was under arrest, advised him of his Miranda rights and his rights under the implied consent law. They attempted to read that back of that BMV form to him in order to obtain the sample, and he became very irate and began yelling he didn't kill anyone, he didn't do it, and he wasn't going to give him any blood sample. The medical staff became concerned that he was becoming destabilized, and the officers stopped talking to him. Because of his refusal to cooperate at that time and given the chemical sample, the officers contacted Judge Vanderkar from the Franklin County Municipal Court, who was the duty judge, to get a search warrant to compel him to give the blood sample.
There was a blood sample.
There was a blood sample secured pursuant to a search warrant signed by Judge Vanderkar, and an RN at the Trauma Center at Grant did draw the blood provided to the police. They sent it to the State Highway Patrol crime lab, and it was analyzed with .191 blood alcohol.
1900%.
Correct, .191. I wanted to indicate that they also interviewed 2 other drivers that were heading westbound on I-670 at the time of this incident, one of whom had to drive defensively and avert the defendant coming towards him that morning, and took their car up onto the berm and hit the wall that's there. There were 2 women also right behind Mr. Canzani's Jeep that became involved in an accident and were slightly injured that morning as well. They interviewed them about what they had observed with the white truck coming towards them. The